It's like,
Well done, well done.
apologize for that.
Thank you so much.
All right, welcome. Hope everyone's doing well. Christine, I heard that gator talk. I was muted at the time. Can you guys hear us?
Yes,
I was muted at the time, so I couldn't say go dogs, but you know.
Go ahead.
I will call this meeting to order. I appreciate you guys being here. We don't quite have a quorum yet. We know some people kind of on the way or they're in other meetings will be logging on later. So anything for which we would need a vote, we'll defer to the end of the meeting. Hopefully by the time we get there, we will have a quorum. That would include the minutes, but I will ask Latoya to go ahead and give us our rules, if you will, rules of the meeting.
Thank you, Judge, and good morning, everyone. Excuse me. I'm Latanya Lawrence, and I'm the program coordinator for the Georgia Child Support Commission. And today I will briefly discuss a few rules to help us navigate the meeting today via our Zoom webinar. The Child Support Commission meeting members and staff are designated as panelists within Zoom and can speak at any time during this meeting. All other participants are designated as attendees and are muted during the meeting, but may type a message in the Zoom chat feature if needed. Also, anyone wishing to give public comment by speaking today may do so at the end of the meeting after the completion of our agenda. Please state you would like to give public comments by typing your request in the chat. Once you are called upon, we will unmute your audio, and our chair, Judge Key, will make the determination on how many minutes you are allowed to speak. In conclusion of today's meeting, staff will post this recording on our YouTube channel, Georgia Child Support Commission. And I'll place this in our YouTube, I'll place our YouTube channel and our chat for everyone shortly. Thank you, and I'll turn it back over.
Thank you. We'll come back to the minutes. I want to take just a minute, if I may, to honor one of our past members who worked so hard around this work. We want to take a moment to remember Deborah Johnson. Maybe most of you probably remember Deborah. She passed away on March 18th of this year. She was an attorney with Atlanta Legal Aid for 30 years, where she served as staff attorney, managing attorney, and deputy director. She was well known and respected for expertise in Georgia family law. She gave her time to support the Georgia Child Support Commission in various capacities over the years. She was involved in drafting the then new, some of us remember the then new, child support guidelines in 2006, and served on many committees and work groups, most recently on the technology and calculator subcommittee. We're very grateful to Deborah for her many contributions, and she will and already has been missed. I know some of you were around, Chuck, I know you were around, and some others in 2006. You were in a different capacity back then, but you were around, heavily involved in the law itself.
Yes, sir. Great lady.
Thank you, Chuck. All right, so done so much work over the last couple of years. You guys have done so much work over the last couple of years that our agenda is not as long as it used to be, but we'll receive some reports now. Dr. Tutter is actually doing a presentation in Texas, I think, at this point.
Yes,
And does he want you to read the report, or we're going to wait to give him a chance to get on? Kurt?
he said he'll be on at 10:40, but I can briefly go over
Okay.
The economic subcommittee.
Let's do it.
So the economic subcommittee last met on August 11th of 2023. Subcommittee's recommended Rothbard basic child support obligation table was successfully implemented into the calculator on July 1st, 2024 at the stroke of midnight. There are no future scheduled meetings for the subcommittee at this time.
Anybody have any questions about that work?
Mr. Chairman, I would just say, Roger and I did chat this morning. We've had some ongoing just sort of informal meetings with ourselves. As we proceed a little further in the fall, when things get a little more focused, we'll have a formal meeting and he'll have a further presentation to the committee as a whole.
Thank you, Chuck.
Sure.
Oh, Noel?
I just have a quick compliment, really, and Kurt may kill me because I didn't even think about doing this until 5 seconds ago. So he had no idea that I was going to do this, but he said at the stroke of midnight, I really want to call to everybody's attention that Kurt was up at midnight and thereafter actively testing the live calculator in the wee hours of the morning between 6:30 and 7/1/2024. And I just found him, he's been with us for 6 months, and him to be a public servant of the highest caliber. And so thank you so much for doing.
Good job.
And also to our IT
Our
colleagues.
IT, yes.
Our IT colleagues who are second to none. So thank you, AOCIT.
Yes, the AOCIT has been working diligently with the updates that came forth on July 1st, and they were up with me as well at the stroke of midnight. So we were on there about an hour or so testing everything out to make sure it was ready for public usage, and then at the day set. So
As the sun came up.
as
And
the sun
I
came
was
up,
only on my text. It was relieved to get a text at about
Yes.
12:40 a.m.
I texted you,
No one
yeah.
tested it.
So are we hearing anything from the field about the impact of the changes?
Well, we could, I'm sorry, you know what, I think I inserted something about the changes, but why don't that's probably, we are, and I have a full report,
Yeah.
but Katie certainly does too. I prefer to her start.
Judge Key, I'm very sorry. Fellow commission members, I'm terribly sorry. I left, believe it or not, with enough time to get here between my house and here I was gonna have more than 10 minutes. I know where the Coke machine is in this building. I do not drink coffee. I drink Coca-Cola, and I left myself time not only to get here, but to even go in and get a Coca-Cola because I know where to do that in this building. And then there was a car accident blocking all but one lane on 75, well north of the connector. So it was exactly where I have no other way to get here. I did eventually get into onto the side thing that's not a lane, where the emergency vehicles travel, and zoom past everyone. I'm sure there are lots of people who were cussing me and fussing. And then, of course, when I got close enough to see the blue lights, I scooped back in. So I was that big jerk this morning, trying to get here, and then I'm still late, but that was when anyway, so my sincerest apologies to Mr. Chairman and the rest of the commission. I do not mean to be disrespectful of your time. I know everybody here has lots going on and it is valuable, so I apologize.
We had just started because we had some technical issues.
Oh,
Not so
shoot.
bad.
All right, well, traffic and technology, can't live with them, can't live without them, so.
Just
Okay,
missed- I just missed it. God, I'm so thankful. Better you than me, but glad you're
Yeah.
here.
Hey,
yes,
did you want to do this now or at another point? Noel? No, okay.
okay, so do you want me to give a report for the statute review committee or address the question?
Just,
I think the question is basically.
yeah, the question, what have we heard about any impact of the changes?
Right, it is. Okay, so the easy and sort of short answer is we're getting really positive feedback. We've definitely gotten questions about cases, specifically, mostly at this juncture, about cases that were adjudicated or settled, whether through, an ADR process or even through a trial or hearing of some kind before July 1st, but haven't yet had an order entered. And, what needs to be done to make sure that the worksheets that accompany an order that it gets entered after July 1st of, 2024, is consistent with the law. We anticipated that, and I had done some research, even calling on old friends from the Parenting Time Deviation Study Committee, like Johanna, who is, of course, also does child support full-time up in not losing my words.
Gainesville.
I'm like, not Gwinnett. Yeah, there we go, the G. Up in the Gainesville area, we even looked into whether, it would be advisable to suggest that people use Nunc Pro Tunc. That is not advisable. When you read it was a good learning opportunity for me when you dig into when Nunc Pro Tunc is appropriately used. This doesn't fit the scenario. So what we've been counseling people is that basically that they need to rerun their child support worksheets, and then they have options. In the settlement context, they can either do a non-specific deviation on the new worksheet to get to the number that was agreed to and is memorialized in their agreement. And judges on the judicial side have sort of a similar option. They can either, run the worksheets and deviate to what they ruled, or if they hadn't ruled and had just taken in evidence, because I've gotten a couple of questions from judges who were in that situation, they could just run the worksheets and determine, from there what the child support amount should be using what was presented in evidence. And that was an issue back in, late 06 and early 07. But it's an issue that I think we can all agree will, slowly but surely sort of, wind down, because there are only going to be so many cases that started, being addressed, whether it's settlement negotiations or litigation before July 1st. And, and eventually we'll get to cases that are all, after July 1st. So that's one thing we've gotten some questions about, and that's, my general report on what the advice has been. I've got it, Judge. Thank you. I've got the executive. Let's see, where else? We're definitely on, and Noelle may have already touched on this, we're definitely on our education campaign, spending a lot of time and energy, talking to, really pretty much anybody who will listen about the changes and how they affect them. Everything from, I know Noelle and Kurt and I are all sort of on our, statewide tour. I don't know, we can name our tour. It's probably not, it's not as hot as the Eras tour. We don't have a following yet, but we are on our own version of a tour. I know I've spoken, I got just a little tiny window at the Family Law Institute. I wasn't really on the agenda, and then they kind of, shoehorned me in. So I did get to at least address that audience for 15 minutes or so and give them highlights. Judge Williford and I spoke, we had a full hour at the Superior Court Judges Conference I think we spoke on July 30th, so that's been just under a month. I've had lots of follow-up questions from judges and staff attorneys from that. The family law section has, I know I mentioned to Kurt and Noelle, have y'all seen it? The Family Law Review has come out and had a big article with, and we tried to, I helped write that article, and we tried to address everything from, Kurt and Noelle's tip about, the new BCSO table and do the copy button, not the, literally we took pictures, and put them in that article. And we've gotten some good feedback from that. I know I'm speaking at a couple of CLEs between now and the end of the year for various audiences. And Noelle and Kurt are doing the same. I will report that Noelle and Kurt and I have had a couple of conversations, and since I spoke to y'all, Judge Williford and I have met, and I think there is a little bit of, what the right word is, but maybe I think it would be helpful to have a conversation about exactly what the messaging is with respect to the parenting time adjustment between now and January 1st of 2026. I think there's maybe some mixed messages. I don't think it's fair to say they're like actually in conflict, because we all have a copy of the statute and know what it says, but I think that maybe the emphasis is different. And Judge Williford and I talked about that last week in anticipation of today's meeting. So y'all want me to share where we are on that?
And I've got like staff's thoughts on that, but I thought you would go through there's like
Okay.
go through your advocacy on it or suggestion on it, and then I'll raise the counter.
Okay, so of course we know, for the first time since our income shares model, child support went into effect, we have guidance on what financial impact parenting time could have. Until now, as y'all know, I know I'm preaching to the choir here, we've had nothing but a deviation option with no guidance. And that's why we ended up with the Parenting Time Study Committee for years and years, and many a public comment, and years of research on it, and looking into what other states were doing, and even our economic studies, more than one of them indicated to us with pretty clear data that it was an underused deviation. We even discussed at times that at some point, we hadn't come to that point, but at some point, Georgia could be at risk of having some issues with our federal funding because of the underutilization of it, and the inconsistencies that resulted from that. And so what Judge Williford and I, I'll just start with what we told the Superior Court judges at the Superior Court Judges Conference is that, undoubtedly, clearly, just as the statute says in black and white, between now and January 1st of 2026, it's a deviation like it always has been, parenting time, that is. However, unlike before, there is guidance now. It's, you know, you don't have to pick a number off the top of your head. You don't have to, you know, sort of mull it over and think, well, you know, $300 sounds good to me. $150 sounds good. You don't have to, you know, we've all heard, you know, tales of judges having their own formulas for figuring it out. You know, I knew of a judge who told me many years ago that, you know, he had done some math and he had a, you know, basically a per diem that, and he utilized the per diem if he was going to utilize anything. And I mean, I was sort of horrified just for what that's worth when that judge said that to me, because I'm like, no, that's completely inconsistent with the economic model. Don't do a per diem. Anyway, we've, so what we told the Superior Court judges is that it is absolutely a deviation, completely within their discretion between now and January 1st of 2026. There's no way around that. That's black letter law. That is what the statute says. However, the formula for the parenting time adjustment passed, and it went through rigorous debate and effort and analysis, and many other formulas were considered, and different exponents were considered, and different factors were considered, and a lot of work and energy went into that formula. And it is now, for the first time, guidance that we've never had before. And that, you know, it would absolutely be appropriate if, you know, and here again, I'm speaking to the audience of judges, you know, if you judges wanted to utilize that formula when you're considering a parenting time deviation in the next 17 months. This is when I was talking to them. We're a month later, there's 16 months to go. And I am counting down at this point because I gave a speech, you know, before that. And I said, we have 18 months and now we're down to, you know, so now we're down to 16 months. So, and then of course, you know, as we all know, and sort of, we joke, but it's true, you know, judges and lawyers as a general rule don't like math. So then they all kind of go, we hear you, the formula's in there, but have you seen that formula? It's terrible. And I don't know how to raise things to the 25th power. And, you know, and so, you know, we told them, yeah, of course, we know that. We never really intended, the legislature never intended for you to have to get out your abacus and try and figure out what it looks like when you raise something to the 25th power and end up with, you know, 10 and 11 digit numbers. We've baked the formula, you know, here's the formula in an Excel spreadsheet so that you don't have to do that. So if you want to utilize the formula that is, you know, past legislation, you know, as your guidance to deviate, we're gonna, you know, it's easy for you, you know, here you go. And that was Judge Williford and I saying, here it is. And we presented them with that Excel spreadsheet. And just for what it's worth, I've actually had now at least 6 lawyers across the state do the same thing uninvited, create their own formula, put it in an Excel spreadsheet, and ping me and say, hey, I made an Excel spreadsheet. I think I've got it. You know, would you check this for me? You know, would you know, I know you know, so will you check my math? For what it's worth, after I got more than one of those, I started saying, here, I'm gonna forward you mine because I've already checked that math. And I don't need to, you know, I'm not a math teacher. I don't need to grade your formula. Here it is. So we have encouraged the Superior Court judges to utilize that as a potential deviation, and really have said, you know, very clear with them, they don't have to. They can do what they want, but if they're going to, you know, for the very first time, this is where they, you know, we have logic, we have, you know, and we're encouraging it. We've also talked to them about mitigating a flood of deviations come, you know, 16 months from now. Modifications 16 months from now. We also talked to them about, you know, that the underlying reason for the parenting time deviation, you know, it's fair to say that because non-custodial parents who are paying child support and have court-ordered parenting time and do not have a parenting time deviation. So that sounds like a lot, but really it's the majority of non-custodial parents in Georgia, because we know that that deviation is actually only used about 4% of the time. So the majority of non-custodial parents in Georgia are paying more than they should be when you consider the economic model that we based the whole scheme on. And, you know, that there's at least some argument that there's not a reason to perpetuate that inconsistency for another 16 months, you know, while we wait for the calculators to be built out. So that's been the messaging we've been sharing. I've had a couple of judges kind of hem and haw and say, well, I'm going to think about it. I've had some say, I'm going to play with it and see if I can get used to it. I've had a couple who have said, I'm going to start requiring it. I'm going to at least require that they submit it to me so that I know what it would look like, and I want the lawyers doing it. Cause I wanna know, you know, I may or may not drop it in there on Schedule E, but I'm gonna require that they do the math for me and tell me what it would look like. You know, I don't think I actually, I don't know if y'all would know this, but there's a family law Facebook group, affectionately known as FLAN, Family Law Atlanta Network or something. But it's very popular, yes.
Love it.
And peruse it at your own risk, because people post, it's family law professionals, you know, lawyers mostly, 99%, I would say, but it's active. And you can, you know, see who's on there. And, you know, they were, even yesterday, I was getting questions on FLAN. You know, well, what are, you know, have the judges indicated if they're using it or not, you know, and I kind of answered what I just said to y'all, you know, yeah, it's not like I can go around and poll, you know, all the Superior Court judges of the state, but some are saying, yes, absolutely. I've gotten multiple emails from all corners of the state since the judges conference. Hey, you know, Ms. Connell, it was so nice to meet you. Here's what I'm doing. Here's a particular situation, and this is how I think it shakes out. You know, does this make sense to you? And I've gotten some, even since I talked to y'all, I forwarded some of those to Noel and Kurt to keep them in the loop. I've gotten some since, you know, where their judges are really exploring it, trying to get their head around it, trying to explain it, you know, trying to get familiar with it. You know, really not unlike what we saw people doing in the first quarter of '07. You know, it's a different animal, and they're just trying to get their head around it. So that's where we are. And Judge Williford and I are encouraging bench and bar to start utilizing the parenting time adjustment calculator as a deviation for the next 16 months. We similarly told the judges at the conference, we gave them the low income caps, you know, not more than 19% for one child. You know, Noel and Kurt, y'all had put that into a PowerPoint, like a four bullets that y'all had used when you presented, I think, to juvenile court judges. So we gave them those same, you know, and
Just
just
to foreshadow what it will be.
right, and just explained that, you know, if they're inclined to at least keep an eye on it, you know, they would use a deviation in Schedule E, but here would be the kind of the threshold numbers. I will say, speaking on that point, the low income, I don't want to take anybody's thunder, but the judges, I feel comfortable saying were widely, you know, there was an easy consensus about their opinion of or support of the notion that when you set child support beyond someone's means, they pay nothing and disappear. And that, you know, just giving them that, you know, reminding them that that's the rationale for the low income adjustment is to address that problem. I mean, across the room, you see, you know, several hundred heads start bobbing. Yes, that we do see that, you know, that if if they feel like it's beyond their means, they just don't pay anything. And so they all really seem to buy into the idea that it, now we weren't getting into the particular formulas or rationales or why 19% or, you know, any of that, but just conceptually, the Superior Court judges, you know, I feel comfortable saying they were, you know, very much on board with the fact that that's a, you know, direct problem and result of the problem. And so they seem pretty open to the low income adjustment. So, okay, that's a lot, but that's where we are right now.
Kurt, Noel, do you have anything to add to that?
Yeah, quite a bit, if I may.
Please.
I just want to thank, first of all, Katie and Judge Williford. We've done some dividing and conquering, and they've done an amazing job. Katie spoke at the Family Law Institute. Judge Williford and Katie spoke before the Council Superior Court Judges Conference. And if you want to get the word out on something, tell Katie Connell, ask Katie Connell and Judge Williford to do it, because they've done an amazing job. So I have a full report on sort of like, definitely, I think their emphasis.
I've got, case I need to speak to you.
Just one second, sorry about that.
No worries. She's jumped right to the parenting time deviation / adjustment issue. So I'm gonna jump to that first, and let's just grapple with that. And then I've got comments just about everything from what we're hearing, because we are on this, you know, tour, the Eras Tour. We're right under Taylor Swift in popularity, but
That's right.
just to give a recap of who we've talked to, Kurt and I and Kurt and Latana and I and all different combinations of us, twice special trainings for GODR, which is the Georgia Office of Dispute Resolution. So we've talked to literally hundreds of registered neutrals. Those are our mediators in Georgia. Hundreds. I mean, I think the first call was 200 and something. Second call
About
was
250, yeah.
yeah, and then the next
Second one
call
about
was
200.
so a lot. We spoke at the annual judicial staff attorney training at the state bar, which was just a couple of weeks ago. That was well attended by Superior Court judges, so that was super helpful to get their ear. We presented to GABWA. We were invited to the family law section of GABWA to speak one evening for a little bit. To DCSS on a statewide call just at the very end of June so that they felt comfortable with the changes. We've posted information, of course, on the commission's website, sent an e-blast to the family law section. Et cetera, and we continue to have requests to speak, including, I was just speaking with a judge in the Conestoga Judicial Circuit up in Dalton, and she'd like us to come speak there. There's a whole, we were on the Good Judgment podcast. I don't know if Kurt and I were invited to speak on that. I don't know if you're aware of it. It's a podcast that Judge Tankel, or retired Judge Tankel and Judge Wade Patchett do, and we asked to speak on that. So we're really getting, I feel comfortable, especially because now we are being asked to speak, that we're getting the word out to a critical mass of people. I do feel comfortable about that. Okay, as to Katie's suggestion to use the parenting, what will be the parenting time adjustment formula as to calculate the deviation amount. Because we had yet to discuss this with the commission, I've remained neutral on the topic, and I absolutely agree, because what's happened is since Katie and Judge Wolfram have been doing that advocacy, I've been asked at least 5 times on all of those calls that I just mentioned, GODR, the staff attorneys, they'll raise their hand. I heard at the family law section, or I heard from Katie Connell that, So this is at least 5 times that this has happened. Also, Kurt recently got a email directly to him from a family law practitioner here in Metro Atlanta, asking him to confirm the math was right that she was doing on the adjustment. So, okay, I have said and continue to maintain until hopefully we get some clarity here today, that it's permissible, that the commission is not taking a stance on whether it should be done or should not be done. Certainly because the deviation leaves it wide open how you calculate it. It's within, it's permissible under the deviation, but I do have some concerns with the commission actively advocating that this should be done or must be done. And I'm going to go through this in no order. This is just my sort of stream of consciousness thought. Currently, the worksheet and the calculator are not ready yet to handle all of the PTA situations. A vast majority, we think, yes, absolutely. But there is a situation that Katie and Kurt, that we've been working on this for years, we call it the flip. The flip's already been organically encountered by a judge in South Georgia who reached out to Katie, and Katie gave her excellent advice on it. But technically, it's the flip actually will change who the paying parent is. And so we don't have the calculator nor the worksheet itself set up to address that. The new worksheet come 2026 is going to have to deal with the fact that in what we think is going to be a small amount of cases, when the parents have either equal or very, very close to equal parenting time, and there's a great disparity in their incomes, we could have a situation where when you use the parenting time adjustment, it's technically the quote unquote custodial parent paying the non-custodial. Now, I want you to just take a deep breath when I say that. And remember, I'm talking about us calling somebody with upwards of like 45% or even 50% parenting time, the non-custodial. So we've gone up and down every flagpole on this, right, Katie? And that what we all agreed to last year before the legislative session is that the money needs to follow the child. And that is why. Okay. So my first concern is we're not, and I'm sure, are you reserving time for rebuttal?
Yes.
So we're not really ready to handle the flip yet, and it already has come up. A judge herself found it. That was wild. Do you think that was wild?
Yeah, I mean, yes, we contemplated I think we didn't call it a flip, but I think the statute contemplated that scenario even before we passed this, even before we passed 454, in that, you know, it contemplated that sometimes in a shared parenting arrangement that's equal parenting time, the non-custodial parent is designated by how the numbers shake out, not by actual parenting time. You know, which is effectively what happens with the flip. I mean, you know, maybe it's not quite as extreme as, it doesn't require an exactly equal parenting time, but it's something very close, and I think we've had that before.
Yeah.
And we have longstanding precedent in Georgia where, you know, unusual as it may feel, and but you can have a custodial parent paying child support to the other. I mean, that's been in Georgia case law and has not been overturned.
But
for a
certainly
long
it's gonna
time.
come up a lot more frequently now that the parenting time adjustment is a mandatory adjustment.
I agree with how you said that. I would add that it's going to come up more frequently with the parenting time because it's a mandatory adjustment and because we're consistently seeing parenting plans that contemplate closer to shared parenting plan.
Right.
It wouldn't come up even with the parenting time being a mandatory adjustment if we were doing what we did when my parents divorced 43 years ago, and dads were still getting every other Friday to Sunday because that's what everybody assumed dads did.
For
So
sure.
I think it is the adjustment, but I also think it is the trends
For sure.
in parenting
change.
plans
Yeah.
that, you know, and don't kid ourselves, those trends in parenting plans are based on decades of mental health research from psychologists that have said, hey, you know what, now that divorce is a real thing and we're gonna see generations raised in divorced families, you know, we know what's good for kids, and more time with both parents and healthy relationships with both parents is what's appropriate. And, you know, slowly but surely our judicial system is making the adjustments to accommodate that. And I think that's what's causing this unusual for us because it's not what we've been doing for all this time.
It's happening in real life,
Right,
and we're now mandatorily accounting for it.
right.
Those two things together, for sure. Okay, I'll continue on my list of concerns.
Noel, while
Yeah.
you're gathering your thoughts, can I just ask one thing, is what your lawyers are asking for in this tool, I'll just, for lack of a better word, this Excel tool, is it generally available to the public? Because that would be sort of my concern as we go through this 16-month period that everybody's talking about something that that I guess it's probably approaching 50% of the divorce cases, maybe pro se litigants, I don't know if somebody could tell us, are hearing something that seems just like legal voodoo because they don't have access to it. So I'll just ask that.
So, it has not been published on, that I know of, let me say, because I actually,
Right.
I don't have control over what other people have done with what they've gotten, and I've had many tell me that they've been sharing it far and wide, and, I would say it is available to the public in that it's in the statute. But the tool itself, is not yet, for example, on the commission's website. The tool, the Excel calculator, has been provided to every Superior Court judge who attended the conference or was registered for the conference, to the entire, I believe the family law section of the state bar has it. You know, in terms of getting it in the hands of the pro ses, I think that's a matter of getting it to the hands of the right people, staff attorneys, judges, you know. But otherwise, I mean, I guess it's sort of like before when we passed the initial statute and, you know, the Excel, when we didn't have a web-based calculator and it was only an Excel-based calculator, it was still a matter of getting that to the pro ses. And did they have Excel, and did they have access to a computer that could run Excel and had an office suite? And, you know, so I think we still have that issue, but I don't think that issue is, I don't think that drives whether to use it or not, because then the other thing, then somebody can turn to them and say, well, the formula's in the statute, go do the math. And of course, we wouldn't actually say that to the pro, I mean, I hope, surely we wouldn't say that to the pro ses, but I think that the idea is to not have to say, it's in the statute, go do the math. That, you know, here, we put the math into this Excel calculator, and anybody can do it. Like I said, I know because I have lawyers emailing me and saying, you know, I took a few minutes with the statute and here I dropped it in Excel because I didn't want to have to do it by hand every time. Will you check my math?
That's all.
Okay, a few thoughts on that. It's a few thoughts. It's the public, but it's also our judges. So I'll get back to that point. But you may recall that when we went through deciding what form, when we finally got to the fact that we should use a formula, there was a big conversation then around which formula. And there was a lot of folks advocating for simplicity. Just so it'd be easier to do. But then we went with this much more complex formula. It takes 7 lines of more than 7 lines of the statutory language. It involves raising something to an exponent of 2.5, not even just a full exponent. So it's a complicated formula, but we promise people, don't worry. The calculator will do the math for you. So jumping back to the Excel issue, judges, one of my concerns is the judges, as of yet, don't have an officially sanctioned parenting time adjustment calculator. Certainly, Katie created an excellent one, and she's of her own accord shared that with him and with them very generously. But it's not been sanctioned by the commission to use to check whether parties are monkeying around with what's actually an easily editable Excel version. So that's my concern. And so then we're putting the burden on judges to determine, is this complicated math that somebody's submitting to me actually correct? Also, do we, this is really good, Kurt, you know, this is gonna set me off. Do we share Excel? I find that problematic. I have been screaming from the rafters about we no longer have an Excel calculator. That got retired in October of 2018. When we pulled about 400 cases statewide in September and October of 2021, we continued to see folks use 5% of the cases were continuing to use Excel. I'm now got my hair on fire about it because prior to 7/1/2024, that was not that big of a deal. But now if you use the old Excel version, any of them, you're getting a wrong BCSO amount. So I may have used the word reversible error and malpractice. So do we do that again? Do we put something out in Excel that we know is hard to claw back once it's out there and then is editable by folks? You know, web-based stuff is in our control and we know there's no way it's giving the wrong data. So for me, using judge by judge, using whether they opt to use a deviation amount based on the parenting time adjustment formula may simply come down to attorney credibility. For sure, they're going to trust Katie Connell, a long-serving, commission member who has her heart in this for decades and, is very well trusted by certainly the Metro Atlanta Bar and bench for that matter. The other thing I worry about is the effective date. We asked for a 1/1/2026 effective date for a reason. And so we've got to think about whether we rush out. Part of my wanting advocating for that delayed effective date was certainly so we could get the calculator to do what we promised it would do, right? That's a huge task, especially because it's running in parallel with the entire modernization project. So there's two major technical calculator initiatives going on at the same time. Also, this educational campaign, so that we're not foisting something so new on folks before they're ready for it. So I really do understand the desire to use the parenting time adjustment formula when calculating the deviation amount for the next 16 months. There's a lot of passion around correcting what a lot of people perceive to be a long time economic injustice around this. So those are my main. So now the question comes down to, how do you want staff to respond when we get asked to confirm whether or not somebody should be using that or not? And do we want to try to get out an Excel calculator? Do you want to sanction Excel calculator? All of that. I'm happy to, that's my 2 cents. I'm opening it. Sorry.
Okay. So I'd like to go to Chuck with this question as former legislator and see what his thoughts are. And anyone else wants to chime in as well. But though not yet law, it does seem to be a clear statement of public policy by the legislator that this is an appropriate way to handle the deviation rather than just being all over the board with it. So Chuck, what are your thoughts about that?
Well, I mean, just very generically, and I have no real expertise on the practical application of this, though I've been listening. I mean, my view is, power abhors a vacuum. And generally speaking, the more we can have, more we can present from a practical, user-friendly, consumer-friendly a basis, either a framework, an outline, or something that gives more to it, because nobody at the General Assembly is going to have really, other than one or two that work in the domestic law area, that would have any expertise. So, you know, I know it's a little bit of a leap in faith, and we've still got a year out there. And if we say anything, does that set a precedent that we then have to unwind later? But my view is I would have something. I think it's better to have something in place to present something, because then we set the agenda, not somebody in the General Assembly.
So we're not ready with the calculator yet. So the question then comes down to, does the commission sanction a version with Excel with all my caveats? Or it uses Katie's version or something. And we're getting somebody in the chat saying, will the Excel calculator be made available to GODR for neutrals?
I mean,
Whatever we
Yeah.
do, it would be available to everybody equally. But we've
I
got
know
to-
it sets a
Also,
precedent.
it's literally on Facebook now, so, and anybody who wants to get it from me can, I mean, I will send it to anyone who wants it.
Can it just be so simple as the frequently asked questions with a link to something you put up, Katie? I mean, somewhere, that's got this tool that we all know is correct, that's been checked and been verified, that doesn't come with an endorsement one way or another from the commission, but provides access to the tools and the resources equally to everybody.
And then we can point them, like, if we get the question, we could, like, maybe not on the, are you saying not on the commission website? but
It
on
could
the-
be on the commission website,
Okay.
just with those caveats. It's not telling anybody that they have to use it. It's correctly stating the law that it remains within the discretion of the judge until it becomes a mandatory adjustment, but at least providing people who know they can come to the commission anyway for information with the information.
Yeah.
And I'll tell you, one of the points, I like that idea, Regina, and I'll tell you, one of the things that, when Judge Williford and I discussed it, you know, I don't think I'm misrepresenting how, you know, she was like, you know, I wasn't wild about an 18-month, you know, ramp up anyway. And I was really trying to defer to staff because that's what they said they needed to feel comfortable with the technology, and knowing that we were gonna, you know, that the commission, or directly, indirectly, the administrative office of the courts, you know, whoever, somebody was gonna be on a contract with, with third-party vendors who were gonna help develop the technology to do this, and we needed to give them enough time to do it. But I will tell you, that is, Judge Williford and I checked each other, and our understanding is that was the only reason for such a long effective date, was to allow the technology to catch up with what the legislature approved. And with that in mind, and it still has to work out. I mean, it is not a long-term solution to say to, judges, lawyers, or pro se litigants, hey, here's your child support calculator, but for this one important piece of it, open up an Excel thing to pull this number. And then, by the way, what you have to do with it is get this number out of here and go back and put it in here. That's not a long-term solution, but we have 16 months to go. And we have, I don't know how many, child support orders that are going to get entered in those 16 months. But for the very first time, we have a formula that has been approved by the legislature to address that gap, and we're giving a workaround while the technology catches up. And just I know Kurt and Noel have seen it, Judge Key and Regina, the link that I send people, and I'll email it to both of you here momentarily, is an Excel spreadsheet. I put 3 tabs in it. The Start Here tab has, a little box, a little disclaimer, although I did a little research on legal disclaimers in case you're interested. As far as I can tell, they're pretty much not worth anything. So just in case you're wondering about that. But I put one in anyway, because what fun is it to have something from a lawyer if you don't add some legalese to the front of it? But I also said, it's up to the judge. This is a deviation. This is a way to utilize, the past legislation, the existing legislation, and our deviation tool, which is all we have now, and sort of merge those between now and January 1st of 2026. And then it says, start here and here's how you do. You put the things in, and then I've included 2 web links. One to Minnesota's calendar and one to Oregon's, because those sort of ended up being the most popular when we were going through it as a study committee and then as the statute review committee. So that they can go and do their own version of the calendar based, to get the number of days, because that's a necessary component to this. Frankly, I think we're all gonna be glad that judges and lawyers have had to start going to the calendar-based things and started messing with it before Georgia issues its own. I think we're gonna be glad that we're not handing it to them for the first time the day it's mandatory and saying, look, this is what it's gonna look like. And here, if you're giving a parenting time, parenting time is gonna be, for one parent every other Thursday to Monday, and then they're gonna alternate spring break, and they're gonna alternate, they're gonna do week on, week off in the summer, and all the things that we see in parenting plans. And by the way, they're asking, and I'm seeing in that Facebook group, which has hundreds of family law practitioners, they're saying, I saw yesterday, somebody posted, oh, don't forget, you do a 2-year average of the parenting time. That's right, that's in our Georgia statute. They
Nice.
saw it, and guess what? Guess what? The Minnesota calculator makes you do the 2-year average.
Right.
So it's in there. So I think we're gonna be glad 16 months from now. I think it's the opposite of foisting something on them when they're not ready. I think we're giving them a training period when it's not mandatory, and it's not reversible error if they don't use it, and it's not reversible error if they do use it. And so far the feedback I'm getting is that they want to be messing with it. They want to get in and play with it. They want to get in and see what it's going to look like. They want to be ready when it is mandatory. And I think this is the way to give them that opportunity.
Let me just add one thing, just as a follow-up from that. And I really tend to agree. I'm putting my former legislator's hat on, having been around when we first adopted and voted on this statute, or whenever that was, 18 decades ago. But I think having more, there's a risk to all. The risk is legislators are hearing from the lawyers in their communities or other people or those affected that this is a mess, this isn't working, there's something wrong with the statute, blah, blah. The other side is, and I agree with what is being stated, I think the risk of waiting for 2026 in a vacuum allows for also sort of complaints or rumblings that they hear back. And it seems to me the risk of having this more information out as opposed to less far outweighs the risk of just standing back and waiting for the technology to be perfected. Because again, if this winds back, or the statute winds up in some level being reopened, added to, or something included in the legislative process, then we all know that opens up a can of potential mischief. And the more we have a pattern and public access and ongoing growing understanding of what this might look like, I think that outweighs the other risk from a legislative perspective.
So like what I'm hearing is that the commission wants, this tool to be available to all, which right now, I mean, Katie's very generously sharing it, but it's very ad hoc who has it and who doesn't have it. So the solution could be that the commission is deciding to put it on what we've got. I've got to look into the technicalities, but have some
Right.
link to some Excel version. And we can certainly do that. I don't know all the ins and the outs of it right now. But then, so it would be at least something sanctioned, but that if you are going to Virginia's point, if the judge adopts this view and wants to use the parenting time adjustment formula as to calculate the deviation amount, that's absolutely permissible. And that's what my concern is. Like, here is the correct way of doing it. So you're not just trusting just random parties saying, yep, here it is, this is the amount, and they don't have a verifiable way to know from a trusted
Does
source.
anybody disagree, kind of, at least that in principle, Judge or Chairman? I mean, is there opposition to that? I mean, it sounds like a reasonable idea to me, but is anybody opposed, or what is the risk, if any? I mean, I'm not the obvious risk, but I'm talking about in the short term.
Judge Land, did you want to say something? I think that you,
I think it's a good idea. I just think we need to be careful about saying this is the correct or the only way to do it if it's not yet the law. Because I see a judge doing this and saying, I'm doing this because the Child Support Commission has told me to do it. And I think this is what the law requires. And then I see that possibly getting reversed because the law doesn't require it yet. So I'm in favor of throwing it out there and saying this is the way it'll be. And the judge still has discretion to do it however he or she wishes to do it under current law, but this is the way it'll be mandated come 2026. And if judges want to do it this way now, here it is. But I think we got to be careful what we're telling judges so that they don't put in their order. I've done it in accordance with this sanction formula that they told me was the legally correct way to do it. And then the other side coming up on appeal and saying, this wasn't the law at the time the order was entered, and therefore we're asking it to be reversed.
Judge, you think that could be wordsmithed to your?
Yeah,
your
yes.
action?
If I may, Judge Land, in response to that, just for clarification, when Judge Williford and I presented to the Superior Court judges, we were very clear with them that if they use it, it is still a deviation. And it is still, as a result of being a deviation, which, you know, we were working on the assumption that they all knew, any deviation of any kind, even if it's just to round out the number so that you don't have, it doesn't end in a 4, it ends in a 5 or a 0, which most people like. It is required to have the appropriate findings of fact, so that it is consistent with current law. And the burden is on the judge who utilizes it, or I guess, the lawyers who present it and, the judge who's signing off on it, to ensure that they are still meeting the statutory requirements of a deviation, which always include certain findings of fact. And so I agree with you, Judge, that is a concern.
And that it's discretionary and not mandated by this formula yet. That's my point. I foresee some judges putting in their orders that I've done this in accordance with the Child Support Commission mandated formula. That's what I'm trying to avoid.
Right.
Well, let me say the case law with respect to deviations is pretty sweeping, that unless, regardless of the rationale, because the rationale doesn't have to be included. If you're addressing the findings of fact appropriately, you're addressing if the child's needs are being met, if the deviation is appropriate, in the best interest, does it prevent either parent from providing adequate support, housing, If the judge says my rationale is this, that's really not any different than the judge who was making up their own per diem beforehand, or just said, you know what, I just feel like $500 is the right amount.
I don't have a problem with that. And I don't have a problem with the judge saying I've used this formula. I just want to be clear that we do what we can to not sanction it as the legally correct formula to use in the next 16 months, and have a judge put that in their order, because it's not necessarily the legally correct formula to use during the next 16 months. It's something that would likely be affirmed if a judge did it. But if a judge, let's say a new judge with no domestic experience comes on board and he says, well, I'm using this mandated formula of the Child Support Commission, I think it's required. Well, that's probably going to get reversed because it's not required yet.
Let me ask one question and then maybe make a comment. Kurt, did you have something first?
Go ahead.
So I do not have Facebook, and I cannot manipulate an Excel spreadsheet. I can look at one, I can't manipulate it, I can't do anything else with it, but look at it. But when we're worried about editing the formula, what we post on our website cannot be edited.
Well, that's
That's the
Right.
what we
problem.
need to
I
look
mean,
into.
somebody could download it and edit
Yes.
that option that they have, but nobody can manipulate what we have on our website.
The current calculator that's on our website that everyone uses, that's a web hosted calculator. So someone, it would be exceptionally difficult for someone to tinker with that, put it that way. If we were to host, this Excel based calculator for someone to download, save to their desktop, and then put their data in, and then they've got their number, they put it in Schedule E as a deviation, that could be easily edited
By them.
by them
On their machine,
on
not
their
our form.
machine. Is Correct,
We can't control what they do with it once they download it.
correct.
But ours cannot be manipulated
So.
on our website.
I
Correct.
need to clarify though, so I make sure I understand your question. Like, certainly the web-based calculator is not editable in any way,
No.
other than the fields you put
Right.
information in. I don't have the depth of technical knowledge to know if we put a link to, if there's some sort of uneditable version of Excel that we could link to. I feel like there might be, like, there's a way to lock it down so you can't edit it. That would be ideal.
I'm not saying that, we can't guarantee what happens once it's downloaded.
Right, like there's many
But
versions,
there's-
Katie's
right.
come up with it, so, and Judge Warren out in Gwinnett
Yeah.
County, and Judge Davis.
Yeah.
Was saying to me, he's getting random people coming to him, like it's happening already, it's out there, like that, these ships have sailed.
Yeah.
People are already actively doing this, so now it's like, do we give public and judicial and staff attorney access to hopefully, like as the trusted source on child support, do we put something out there right now?
Now, I think everybody's in agreement that it would be in the public's best interest for us to put out something out there that reflects how it will be calculated January 1st, 2026. As a guide for those lawyers and judges who want to follow it as a deviation, use the basis for deviation during the next 16 months.
Right.
And that's
Making
just,
clear,
Right,
that's as far as we go, and let the lawyers do what they do. And the lawyers can try to convince a superior court judge that, this is a statement of public policy, even though not in effect. I want you to rely on it in making your finding today, and another lawyer can explain why not. And let the lawyers worry about that. We just put a guide out there that makes it easy for judges and lawyers to have something to work with without doing the math. Does that?
That would take care of my concern totally. I mean, basically this is what's coming. You may consider this now in the next 16 months, but you're not required to do so, but here it is.
Right, and I agree with
that.
that. Judge Land is spot on, and just so he doesn't think I'm just being contrarian, the last 3 slides at the Superior Court Judges Conference were all about, but it's still in your discretion, you deviate as you see fit. By the way, even if you apply the parenting time adjustment after January 1st of 2026, you're still gonna have the option to deviate. So, that option is not going away in the next 16 months or post January 1, 2026.
So if there's no objection, I'm gonna state it, and I don't hear any objections, but it seems to me what would be appropriate is I think that we need to give staff some cover. We also need to be on the same page as a commission. So I would like to ask staff to deal with the technical issues about manipulation on our website, not after it leaves us, and to draft sort of the disclosure that you want to make about its purpose and present it to the commission members, and we'll just maybe vote on electronic once you have it completed.
and I'm happy to say that we've reached quorum. Dr. Tedero has joined us, so we now have 8, just in terms of the business of this meeting, we now have 8. But we are happy to do that,
Okay.
or if you want to, yeah, let's do that.
I don't think that calls for a vote. I think I can ask
Yes, yes.
the commission to do that in conformity with our discussions and concerns expressed at the meeting today, and then we'll put it out there.
And I can do a little bit more research on what level you can lock down an Excel spreadsheet.
May I just address, to that point, I understand the concern. But I also think we need to be mindful that there are going to be people out there who are going to try and manipulate when they're in litigation and present something to a court that's not accurate, and we have all kinds of safeguards for the bar, I think there's only so much we can do to control it, and I don't think it is the commission's obligation to. I think what we put out there has to be accurate, but if someone takes it and then intentionally changes the underlying formula and presents it to a court as true and accurate, that is a fraudulent representation of the court. That is not on us. That is on them. And if it's a lawyer, then they're breaching the rules of candor to the tribunal. And if it's a pro se litigant, then it's a version of perjury. And I don't think that, and frankly, if it's available on there and a judge is concerned that that is happening, then the judge can go right to the website and plug it in themselves, if
Well,
they.
now that will have it, like, if we.
And
That's what I'm saying. That's what I'm saying. So if it's a concern that somebody is going to effectively, to put it simply, lie to a court,
Right.
using, I don't think we can control that. I think people do crazy, desperate things, and that's just
But what's making me comfortable is now the judge would have a trusted source to go to double
Right.
check if
Right.
they feel they need to. That I feel more comfortable. with
Yeah, and-
Than just it happening
And
like whack-a-mole.
And that's something good, you know, about your calculator, Katie. I mean, it's easily checkable. I mean, it's very user friendly. So if a judge just, you know, maybe they did have a question, maybe they didn't know this attorney, whatever. Or they had any reason to suspect anything, you know, they've got their own version, they can download it from the commission site and boom, punch in the numbers and they either match or they don't match.
Unless there are any other further concerns about this, that a commission member wants to address the staff, and that's their assignment.
So the only thing I will say is, I agree with kind of what Judge Land was saying. I think the way that it's presented, the disclosures or whatever language we use would have to be very, clear so that there's no kind of blowback. But I also agree with what Katie's saying. I mean, basically at the end of the day, if someone wants to manipulate something, if they want to use it for whatever ill intent, that's the reality of life sometimes, unfortunately. But I think we just have to be really careful and really clear. I think it is good to have something that that the judges and litigants can, at least have an idea of what that deviation looks like before 2026. So ultimately, I think it's probably a good thing.
Thanks to all the commission members for your input, and thanks to Katie and Judge Williford and staff for all the work you're doing on getting this out there and dealing with all the questions. Anything else?
Yes, unfortunately,
All
I'm
right,
sorry.
go ahead.
But so that was just my report out on parenting time adjustment,
Right.
which by far is the most complicated and I would say probably our biggest change. But I just want to make sure I'm whipping through the other general feedback on all of 454.
Yes.
Which is obviously for. So I totally agree with Katie. We're really happy to report that there's generally positive feedback, and there in no way has been any sort of overwhelming negative response whatsoever. If anything, I do get this sense of like relief and or gratitude that there will now be guidance on how to
Right.
account for
Yeah.
parenting time with that switch to using a formula. It's a relief to people, even though it's a very complicated. So and the other thing is we're certainly getting questions because these are big changes, but I'm also happy to say no questions or comments that haven't already been grappled with over the last 5 years through umpteen meetings, 20 some odd, right? Katie, we're in the trenches together for a long time. Nothing that we didn't ask ourselves or consider and discuss. So there was no like, yikes, we never thought of that. That has not happened yet, which is just like a great relief to me. Some folks worry about that it's hard to calculate. We know it is, but that's why the calculator's going to do the so we explain that to them. There's a single new field in the calculator. Well, it's been kind of fun to say, Schedule C will be back, like it's back from the dead. And so that's kind of fun and something fun to like make some sort of child support joke about, but that we no longer go from B to D, we know our alphabet. But so but it's only asking folks to add a single data point in the calculator, and that's the amount of parenting time. So then they, of course, they'll worry about, will this can create what I've been calling litigation friction points, or what we also call cliff effects are. But we explained that the formula that we specifically chose was the non-linear method, as it's called, and it removes cliff effects. It means any slight change in the amount of parenting time somebody has does not move the needle that much. There's not going to be these huge incentives to get 1 or 2 more nights or anything like that. So that then gives people comfort. You're I'm sure finding the same thing.
Yep.
Yeah. Okay. They are worried about having to count days and figuring out, well,
Yes.
how many days do I have? I've got every other week, but what does that mean? So we acknowledge that that is an issue. That is the one data point that they now need to come up with that is in addition to the current requirements of the calculator, but that we are actively working on embedding a tool within the calculator
Yes.
to help folks. Similar to what Katie was saying, similar to what Oregon does and what Minnesota does, to help them come up with that amount. And to Katie's point, I totally agree. We know the family bar is going to come up with their own little cheat sheet, like, oh, they're gonna know. They're gonna know, probably to your point, before it becomes a mandatory in 16 months. But then sorry, this is my notes, what we all just went through them us wanting to. Okay. We added a new field to the worksheet. There's now a creation date field printed on the worksheet, and this was done to make it plain on the face of the worksheet that it was created on or after July 1st. So somebody, it's obvious that it's using the new BCSO table or the old BCSO table. This is because the calculator needs to continue to have two tables in it. It's something we had, anyway, it was a technical issue that came up when we were implementing SB 454. So that historic worksheets continue to show that old BCSO numbers and don't automatically update when we on 7/1/2024. Old worksheets continue to pull from the old table, new worksheets will pull from the new table, and there's a new field. At first, it showed date and time, and we were getting some negative feedback that folks were concerned because the time field related to not where the person was sitting using the calculator, but the web-based server time. And so we've already removed the time field, but it will continue to show the date field. So somebody couldn't use update an old worksheet and get old BCSO numbers that aren't legit. Okay, that's why we did that. Chief Judge Bagley, Superior Court in Forsyth County, reached out to a handful of people. I was copied on that correspondence, raising a codification issue around 454. And of course, because of our sort of trifecta of effective dates, it got codified in an interesting manner, or like a challenging manner. It's not run of the mill. I sent a couple of emails to folks about that. I also met with the judge's staff attorney, and I think it's settled. It comes down to having to really carefully read both the general notes section in the statute and in the code, I should say, and the editor's notes. But once you do that, I would say it's clear as mud. No, it gets clarified, but it's not easy. So I think I haven't heard from them any further. That was several weeks ago at this point. So I think that's put to rest. You'll find this funny, Katie. I did hear from one judge, this is hearsay, but through a very trusted source. The Superior Court judge after the conference said, well, I'm just not going to order more than standard. So I haven't said it yet publicly except on the podcast, but I'll continue to make sure this is really clear. There's no threshold for the adjustment amount. It will start with as little as one overnight. Yeah. It's going to be perhaps 50 cents worth of adjustment, I joke, but it'll be an extraordinarily small adjustment amount with one night, but we're still dealing with the folklore that the BCSO table has any sort of parenting time baked into it. Okay, I'm almost done. There were a couple questions around clarifying whether the parenting time adjustment only applies to court-ordered parenting time, and we've of course heard it says that like 57 times in the statute that it's only court-ordered. I think this may be a concerted effort because out of the blue, I'm suddenly getting peppered with questions and requests around the high income deviation. I'm going to just repeat that, the high income deviation, not the low income deviation, saying there needs to be more guidance and why isn't there a formula for that? So we are going to respectfully request that we at least take it up at put it on like a statute review agenda. It's an interesting topic and Kurt and I discussed it. We looked into it, but
I suspect the statute review committee's agenda is already in the works. I know that Judge Williford and I have already shared the bullet points we think should be on it for our next meeting.
yes,
And we can certainly add that to the list.
Yeah.
When's your next meeting?
Our next meeting is
In
next month, September 10th.
10th.
Yeah, September 10th. So
And last but absolutely, like, not the least by any stretch, but we have gotten some general questions about the new VA disability credit, is what we've been calling it. There haven't been any problems or complaints about it. I think it's just folks trying to confirm that they understand it. But we were asked by one mediator who remained anonymous in the chat. It was quite interesting. 3 times in 3 variations of the same question asked whether that credit could go toward arrearages. And 3 times we had to clearly say no. So that was interesting. But so that's what we got.
Any questions? Noel? Right, Notaro's with us. He gets the award for the furthest away. He's in Texas, I think. But I appreciate you logging on the meeting. Kurt shared your report, which you couldn't hear, so you wouldn't have anything to add, I guess, but Dr. Tutter, anything you want to say?
No, thank you so much, Judge Key. And I spoke with Chuck yesterday and Kurt and I swapped emails. So thank y'all for covering for me.
Right. You. All right, that would move us then, if I'm correct, Technology Calculator Subcommittee, Regina.
Thank you, Judge. Our subcommittee did meet on June the 12th. And 2 previously approved changes to the calculator for the radio button on Schedule B and the juvenile court case filing have now been successfully implemented into the calculator. All of the statutory changes to the calculator that Senate Bill 454 gave us that we've now discussed in this meeting, and I will not rediscuss, were deployed on time and on schedule, and there have been no reported issues with the changes, those changes that went into effect July the 1st, and I can't tell you how rare that is in a government IT project, and I won't get into any specifics about other government IT projects. So we know that the work on the parenting time adjustment will continue, the low income adjustment will continue. So we will continue to have meetings. The date of our next one is pending my confirmation to staff, but we expect it'll be September the 13th. And all this time, the calculator modernization project continues to move forward with a deployment time of late 2024. So later this year, technically speaking, no pun intended, with governmental work, the purchase order was approved on June the 18th. And so it's being funded appropriately through the AOC funds. And, that's the team is having to work not only with doing that, also with the calculator work at the same time. And that's been discussed as well in terms of the delayed effective date. Will be a lot of IT work. So that's what we're doing. And I'll be happy to try to answer any questions, and staff can jump in here and emphasize what I've missed.
No, a little bit of good news. We met with our IT department yesterday, and we hope to be testing the new calculator at the end of next month. So it is chugging right along, if not a little bit ahead of schedule. So
Good news.
No one cares about this but me and perhaps Regina. But I'm glad to hear about these technical advances at AOC, because we have Senate Bill 401 that we've got to get up and running fairly soon. So I expect them to be on time. Maybe before midnight on the day. So, thank you for that report. I know nobody really realizes the work that goes into the committee work in this commission unless you're here and you watch it. So I have the opportunity to be the chair and just conduct meetings, and you guys do all the work between staff and committees, and I appreciate it. You make it look good. So, and that's not easy. So thank you all for that. Anybody have any questions for the technology and calculator for Regina? Okay. That would move us then. Let's go ahead in case somebody has to leave. We now have a quorum, right?
Yes.
Let's go ahead and circle back before we do new business to the minutes. The minutes have been distributed. Everyone's had an opportunity to review them. Are there any corrections to the minutes offered? All right, hearing none, the minutes stand approved as submitted. Thank you. All right, so new business, permissive land deviation and dependency cases. This is an issue. I didn't ask you this before, but Noel, do you want to give a little background before I kind of say where we are or how this came up?
Sure. So,
Sorry to put you on the spot. I know you can handle it.
So this sort of bubbled up organically around our work, in particular to provide juvenile courts with a specialized case caption that they requested. And so that's something we worked on, certainly with Regina and her committee, and the calculator's now doing it. So I spoke for two purposes before the Council of Juvenile Court Judges to introduce that work and then also to give them a basic primer on the upcoming 454 changes. While I was there, talking about the new case caption that the calculator can do for them, sort of, some discussion broke out, I would say, and strong opinions on whether child support should be ordered, like the bigger, not just how to calculate it, but whether it should be ordered in dependency cases. And dependency cases are cases in juvenile court in which a child's been removed from their parents. So it also came up, we sometimes do trainings at the request of different judges or courts or groups. And a year or so ago, we did something for DeKalb County judges, and the same question came up. The judges bursted into a conversation amongst themselves about when it is appropriate. And I would say from my, you can speak so much more eloquently to this, but there's some cases in which it's clear that it should be ordered. But there's a lot of cases and they're very, very sensitive cases. And do you want to speak? I don't want to step in. I don't want to speak on it.
We don't want to talk a lot of detail about this. We'd hope to have some other people speaking with us today at the commission meeting and actually maybe getting some traction on this issue. But those very same people are at a conference that the Committee on Justice for Children is holding this week. So they canceled. We're going to bump it out to our next meeting, I think is the plan. But when a child comes into foster care, one of the things that happens is assignment of rights to child support that's assigned to the state. This goes way back in the day when they used to call child support enforcement. Child support recovery back in the day. And the idea was to recover from parents some of the money for the cost of foster care. And in most jurisdictions, not a lot happens during the time that the juvenile court has jurisdiction in those cases. But I don't see this much at all, but apparently what's happened in some cases is that when that assignment of rights is made, the Division of Child Support Services will file an action against the parents in the dependency case and apparently not apply the deviation. There's an acknowledgement in Georgia law that if a parent is working a reunification plan, it may be difficult for them to pay guideline child support. So the court is authorized to deviate from the presumptive amount of child support without guidance or direction of what it might be, but to fit the circumstances of that case. And I don't know how these happen. I don't know if nobody tells the judge or the administrative judge, whichever it is doing it, about the child being in foster care, but we have some large awards coming out against parents while they're working reunification plans. Just what's caused it to bubble up. That's never happened in my court. I have had non-custodial parents being ordered to pay child support. I don't have a huge problem with that. But that parent that's working reunification plan usually can't pay it and do all those other things we expect them to do to get their children back. And there's been a movement apparently set out in a guidance letter from the administration or ACF, Administration for Children and Families, towards eliminating that assignment. So basically, we think, when I say we, and staff and others have talked about it, it's anything that affects the best interest of children, anything, we have responsibility to make sure we have laws enforced that result in appropriate awards of child support in the state. And so we think it's within our purview to take a look at this, and we'll be doing that at our next meeting. It may be a matter of education of a Division of Child Support Services who handles these cases, I think, for the department. It may be a matter of education for our Superior Court judges who enter these awards. But we need to find out why these things are happening and see if we need to make legislative or policy changes around it. That sum it up pretty good, Noel?
I think perfectly.
Might any questions about that for today?
Judge, my question would just be, is there record keeping? Would there be any way to know how, is this anecdotal, or would we be able to know how numbers?
I think they're outliers. My practice in all these years, I've been on the bench 35 years. We have judges conferences twice a year. We talk to one another, and I never hear of this happening, but it is happening some out there. So I think, again, there may be outliers that we need to be.
So what I will just say about that for our next meeting for staff and for anybody else that is making plans. The statute is 1911-6 that requires the assignment. In 1911-6A and specifically includes the foster care maintenance payments under 4E, not other complicated sometimes, but under 4E funding. And then defects in the Child Welfare Policy Manual, which is public facing on the Otis website, is policy number 9.12. And I will get that to staff before the next meeting so that everybody has what, if it remains on the agenda, everybody has what we're looking at here.
If I'm not mistaken, we have to adopt that as part of state law in order to get the 4E funding, if I'm not mistaken.
Well, I will say that the state law is sort of black and white, and the federal regs always have nuance. And the defects and our division of child support services tries to serve both those masters, which is where the policy comes in with hopefully the right nuances.
Thank you.
And Judge, may I add, I think it's really important, Judge Key highlighted that joint letter from both the Children's Bureau and Federal Office of Child Support Services. That's a really good place for everybody to start. It was included in the meeting materials, but I think it gives an overview for folks that are not really familiar with dependency cases, some sort of, orientation, background on the whole
Yeah.
thing.
And I will say juvenile court judges are authorized by statute to order child support. During the time we have jurisdiction, that order does not survive our jurisdiction. So when custody is returned and we close out our case, that order goes away. There is differences of opinion among juvenile court judges as to whether it should be ordered at all. Some judges believe that we should order a reasonable amount of child support. Sometimes it's as little as $50 a month. Some of our judges that do it at all, used to would apply the low income deviation, as a matter of fact, to make it fit, or use that number to make it fit, to demonstrate the capacity to be able to care for the child and get the child back. So it's just views of, judges are all over the board on it, even those that order child support at all. A lot of our juvenile court judges do not order child support.
And my basic understanding of the issue from multiple people, to your point, I don't know if we have like hard numbers on it, but from the current president of the Council of Juvenile Court Judges, Neil Brunt, and from a colleague of mine who's done family law and child welfare, what's happening is there's some mechanism by which defects cases, the sole issue of child support is being plucked out of the dependency case, referred over to their colleagues in DCSS, and just run through the automatic steps that they would typically do in just a typical case, without perhaps the sensitivity about this is an extraordinary sensitive situation, not knowing necessarily about the dependency deviation, and they run it up through Superior Court. And Superior Court has no idea about the underlying facts of the dependency case and just set child support at the normal, sort of the guidelines based. So that's my understanding of the kernel of the sensitivities and issues.
Yeah, that's where some of it comes from. That was also the assignment. So I guess the Division of Child Support Services.
Right,
So
right.
more on that the next meeting. Somebody has questions. So Judge Jones gets this from a couple of different perspectives because she's a juvenile court judge and also sits in a lot of child support cases.
Yeah, I think that, I'm kind of, as much as I think sometimes I don't really have the time to do the child support cases, I've been doing them for, 20 something years. And so I have my, eyeballs on these families and it works well. But I think it is our responsibility as juvenile court judges to order some support, at least token support, when we have parents working a reunification plan that are employed. If they're in inpatient rehab or something like that and can't, but, I'm one of those judges that I may order $50 or $100 per month just to show that, you understand that you're not bearing the financial responsibility of caring for your children at this point.
And one other thing about in juvenile court, and I actually, this is really getting a far field here. I'm actually an advocate for, in these cases where juvenile court judges have jurisdiction, being able to order child support that will survive our jurisdiction and be enforceable in the Superior Court. For a number of reasons. Number one, both the parents and the children are represented in our court. We know more about the situation than anybody else. For a lot of our custodial parents, we can create a stream of income that allows the child to remain home or return home. So the custodial parent has the funds to provide safe and stable housing for the child. So we can make a greater impact around child support in these cases than we can do under current law. But again, maybe we'll have a broader discussion later. Any other comments?
It is, it's just, taking the time to, analyze each case. You have to appreciate the circumstances of every child and every parent that we deal with. There's really no, blanket ever, in my opinion, no blanket number.
Thank you, Judge Jones. The next item on the agenda would be public comments. I'm not seeing any member of the public. There's no one in person from the public, and I don't see anyone online. I don't know there.
We do have 4, but I've typed in the chat that if
Oh, I
you
see.
would like to make a public comment, please type your name in the chat, but we do only have 4 guests.
And has anyone requested to make a
Not yet.
comment? I just can't see them. All right, I guess there is no public comment then. The next meeting, we're having some difficulty scheduling that. We're shooting right now, I think for November the 22nd. And it will also be a hybrid meeting, including perhaps your chair being in Gwinnett County that day. I'd rather be here. So. All right, anything else to go to the order? All right, it is now 11:36 and we stand adjourned. Thank you all so much for your contributions to the commission.
Thanks, sir. All have a great weekend.
Thanks to staff.
Thank you, staff, too.
Thank you.